Hello folks, welcome to Legacy Eyes Academy. In this video, we will be discussing a current affair compilation for your polity for the month of February 2025. Now, this current affair compilation is strictly from your prelims perspective, which means those of you who are taking up the prelims exam in 2025, this video is for you. Now, in this video, the way we will be discussing topics will be again, like I'm mentioning, prelim specific, and also it will be in the form of questions, multiple choice questions. So, you will know what kind of questions can come from this, or how can you eliminate the options, or how this particular topic or content knowledge will help you in solving other questions in the prelims. All right, let's get this video started. This video is presented to you by your faculty, Sushma KP. Look at this. In this February month polity current affair compilation, we will be seeing this of 2025. We will be seeing the topics of constitutional morality, status of devolution to panchayats and states, three language formula, President's Rule, Obscenity Laws in India, Article 10104, Delimitation Exercise, National Commission for Safai Karamcharis, and Rarest of Rare Doctrine. Okay. As usual, I will tell it to you like a story. You listen to it like a story. But before that, we have a small announcement from Lexi IS Academy, wherein the classes for this year have started. If at all you're looking to join and be a part of your UPSC civil service preparations and make your dreams come true, I would suggest you check into our Legacy IS Academy website, where the batches are starting from April 17th onwards. Now, when I tell this, you have to check it too. It's not like your any other just promotions that we do. One important thing about your Lexias Academy is it offers things which are very student specific and friendly. What do I mean by that? Our batch size is strictly maintained at 40 member per batch limit, not more, so that your personalized attention can be given to you. Second thing, irrespective of what your background is in your graduation, post graduation, let's say you have worked, you've stopped, any of these conditions, pay, it doesn't matter with your background of your graduation, because in Lexia Academy, before starting all the advanced classes, we give our foundational classes. NCRT classes are covered in depth and what has to be studied from your NCRTs, because your NCRTs are for 6th, 7th kids. Those are not for you. How to prepare for that NCRT for UPSC will be taught in a detailed manner. So your base will be made strong before we take you to your advanced curriculum. If at all you want to check out, okay, I need to see how the classes are, then you can go to your Lexi IAS mobile app, wherein you can have access to instant demo classes. First thing. Otherwise, if you wish to come to the online, that is, come to the center and directly attend any demo class that you want, you can ask for an appointment. You just have to contact the number given below. All other details about your admission process is all present in your Lexi IAS Academy website, or you can even contact the number given below. And any much more information that you need to know about the curriculum course, etc., the link for this will be provided in the description box below. Do check that out. And for those of you who are writing prelims this 2025, Alexia's Academy has started free All India Prelims mock tests. Take advantage of this, see how your preparation is, and what course correction needs to be done. All right? Now, the very first topic that we will be discussing today is about your constitutional morality. What do we mean by constitutional morality? See, in normal terms, you have heard of morality in multiple times. We need morality, or a moral, or a humanness, or basic sense of moral values which are needed. You would have seen in your schools and all, they would be having moral class, moral education. So you try to enshrine some features such as what is good for the society, so as to you live in a society, you are going to be in a society, and how will you develop and inculcate that societal beliefs, value system, shared opinions. No one is telling here you have to become a part of the herd, but at least you are a part of the society, so you have certain basic norms which you do have to follow so that you and others can let live. The same thing if it applies for an individual, then on the whole concept of your entire constitution, which is guarding these people, guarding the personal rights of individuals, then that also should have some morality or basic set of values that a constitution is to possess. What are those? What are the elements of constitutional morality? Freedom of expression, a right to equality, due process of law, social justice, rule of law, preamble, individual liberty. I suggest you write these down in point wise. Now let's take one example. Preamble. Your preamble has multiple things such as justice, liberty, equality, fraternity, unity, integrity. So basically, these are all the ideals that are very much needed for something to be called as a just society. And India claims it is a mixed economic model with a strong socialism. And our socialism with mixed economic model is very much what is the need of the hour right now, when you cannot run away from globalization. You cannot go to a stage of your closed economy which India was before 1990s. Both are not feasible. But a culmination of both is what your LPG and especially mixed economy model of India is. At this point of time, your constitutional morality now sets forth a generation, that is our 21st century, with the needs of the society incorporated into our constitution. See, time and again, you would have prepared for mains, you prepared for UPSC, prepared for prelims, all of these stages. So, one basic things would be when you read polity, you will come across things such as disadvantages or criticism. What is the criticism of DPSP? What is the criticism of fundamental right? What is the criticism of this? And all these things, you will see there. For example, let's take DPSP. It is vague. The criticisms are it is too vague, it is too generalistic, it doesn't have a free flow of ideas, and it doesn't have issues which are presently faced by people depicted in it. For example, your LGBTQIA plus community struggles. So the criticism is it is not evolving to the time, it is not taking things which are considering the present scenario. Somewhere 1945 you made it, you cannot keep continuing with the same thing. You have to, for example, look at this: freedom of expression, individual liberty. Might be freedom of expression would take a background in certain places, but today present scenario pe, if I have to quote this particular thing with regard to freedom of expression, that is information, I have to quote Thomas Jefferson on this, wherein he claims that your freedom of expression is the currency of democracy. So, your freedom of expression is very important in now scenario more than ever. So, your constitutional morality has to house certain things which will make sure that irrespective of what period of time we will change, those can be easily adopted into our constitution. Understanding? See, for example, due process of law is not mentioned in our constitution. Procedure established by law is mentioned in the constitution. But do you think our judiciary only looks into procedure established by the law? No, it also looks for your due process of law. How is it able to do that? How is it able to adapt to it? Because of our constitutional morality, we are able to invoke things within it which were not there maybe 75 years ago, which may not be there another 75 years further. But a provision to incorporate, that is your constitutional morality. Understanding? The credit for coming up with your constitutional morality, which was based on your Athenian democracy, goes to your George Groot. Even B.R. Ambedkar is held, saying that your constitutional morality is very key important concept if you have to realize democracy. Few of the past Supreme Court judgments. See, here I would suggest knowing few important one of those, because it sometimes they tend to ask this particular concept is related to which particular Supreme Court judgment or judicial pronouncements. Navtej Singh Johar versus Union of India. This one particular topic they have asked your Navtej Singh case in many times in your state exams as well as your UPSC exams. Affirmed LGBTQ plus rights under Article 14, 19, and 21, emphasizing constitutional morality over social morality. Okay, so you have to know Navtej Singh Johar versus Union of India case is regarding your LGBTQIA plus community, and we see your constitutional morality over social morality. Yeah. Next is your Indian Young Lawyers Association versus State of Kerala. This is nothing but your Sabarimala case. Okay, and look at this. Public morality cannot override constitutional morality. Next is Joseph Shine versus Union of India case. This is more specifically individual autonomy and dignity, reinforcing constitutional morality over outdated patriarchal norms. Next is K. Puttaswamy versus Union of India case, that is your right to privacy case, wherein individual freedom, dignity, and which in turn reinforced constitutional morality against state surveillance. This was your Aadhaar case, where they questioned the validity of Aadhaar, which houses all your biometric data. Union of India versus Government of NCT of Delhi. Strengthened federalism, democratic governance, preventing executive outreach. Again, strengthening constitutional morality. Okay, so these are some of the important cases you should be knowing. Now, our constitutional morality in Indian constitution, like we discussed, it is there in your preamble, fundamental right, DPSP. Now, we will learn more about this topic with some of the questions. Okay. Hope you can see the questions properly now. Consider the following statements regarding constitutional morality. Constitutional morality refers to, first I will read out the questions, then we will discuss the answers together. Constitutional morality refers to the ethical principles and values that guide the functioning of of the constitution in a democratic society. It primarily relates to the moral values of the individuals holding public office rather than the constitution as a document. Constitutional morality places importance on upholding the fundamental principles of constitution such as the rule of law, justice and liberty. Which of the above statements are correct? Now look at this. Constitutional morality refers to ethical principles. Like we said, how an individual is supposed to have the state, your constitution also will have that. Ethical principles and values that guide the functioning of the constitution in a democratic society. This is correct. Because it primarily relates to moral values of individuals holding public office rather than constitution as a document. Here when we say individuals holding public office, which means your MPs, MLA, bureaucrats also. So do you think constitutional morality is about them and not constitution as a document? This is a wrong statement. This is for constitution as a document. Constitutional morality places importance on upholding fundamental principles of constitution such as rule of law, justice, liberty. This is correct. In basic, in simpler terms, if you have to understand what is constitutional morality, you understand it like these are the basic set of values or things or principles that a constitution should have in order to be called a constitution. So, the correct answer is 1 and 3 only, which means A is the answer. In the context of constitutional morality, which of the following statements are correct? The concept of constitutional morality was first articulated by Dr. B.R. Ambedkar. It is concerned with upholding the values and principles set out in the Constitution, even in cases where political power may be at odds with these values. The judiciary has a crucial role in enforcing constitutional morality, especially when there is a conflict between state actions and constitutional principles. Look at this. Concept of constitutional morality was first articulated. See, one of the major proponents was Ambedkar, but he cannot be attributed to being first person to have brought out this topic. So this is wrong. So if you remove one from the option, correct answer is 2 and 3 only. Answer is B. The idea of constitutional morality is closely linked to which of the following principles? Federalism, rule of law, secularism, fundamental rights. Correct answer is your rule of law. B is the answer. Which of the following is not an example of the application of constitutional morality? A government decision to override judicial rulings in the absence of strong constitutional justification, the protection of the rights of minorities even when it is politically unpopular, the enactment of laws that promote equality before the law as enshrined in the Constitution, the use of political power to respect the independence of the judiciary. The correct answer is A. This is not an example. Government a decision to override judicial rulings in absence of strong constitutional justification. This is not constitutional morality. The next topic that we will be discussing is status of devolution to panchayats in states. First word, devolution, which means division. See, if you see a lot of commissions, interstate councils, center state councils, Sarkaria commissions, your Niti Aayog, all of those are about bringing two things: cooperative federalism, strengthening concept of federalism, that is good working between your center and states. One thing that is hampering, in fact, to so much so to an extent, in our basic structure, concept is not defined as to what constitutes the basic structure because it is left to be broad. Like I said in the previous example, constitutional morality is supposed to be which will be housing things which might be important in 75 years later. Understanding? So it has to have room for growth. One such thing is with respect to federalism, you can consider it is a part of your basic structure. Center and state correlations to be smooth is important for easy functioning of the country. For this to happen, constant conflicts between your center and state is division of powers, division of resources, division of money. So basically, this division is where the issue comes in, where one claims the other is encroaching, where one claims the other one doesn't even have jurisdiction on this issue. Now, between center and state itself, so much issues are there. Means, then imagine what will be the case of your panchayats. These two itself have that much of cat and mouse fights. Yes, so then imagine how it will be with these to this. So we are a three-tier government, that is we have center, state and local bodies, but we did not have this from the beginning of the constitution, that is post your 73rd and 74th amendment. We got three-tier Okay, we got three-tier structure wherein center, state, and panchayats, which meant that state had to carve out certain things and give it to the panchayats. Okay, that is your devolution of panchayats and states. Now we will see one important thing is this is not a completely pan-India concept. The concept of panchayat is pan-India. Again, there also issues will come with respect to your fifth schedule, sixth schedule. That is different, where it applies with extensions, your panchayat extensions, yeah, in tribal areas. Let's keep that separate for now. The concept of panchayat is uniform throughout the country, but how the functioning of panchayat is, that is up to each state government to decide. Now we will see how each state has performed with respect to devolution, that is division, be it with respect to administrative, finances, okay, or even staff for that matter, resources allocation, all of those. Look at this. Union Minister of State released status of devolution to panchayats in states. The result is there is an increase in panchayat devolution from 39.9% to 43.9% in over a decade. That is from 2013 to almost 2022. So, in almost over a decade, there is a significant increase. We cannot call this significant, but there is an increase from 40% to 44%. Look at this. Based on the findings, financial devolution has increased, which means funding for your panchayat raj institution has increased, and also functional devolution declined from 35.3% to 29.8%, which means there is limited administrative transfers. Capacity building has improved from 44% to 54%, which means there is good investment in your governance initiatives. Personal management has increased from 39.6% to 50%. This again because of your staff recruitings, you know. Accountability and transparency grew from 46% to 47.5%. This has not been very large, but somewhere a change of its sort. Now, if you see, Karnataka has the highest devolution state with 72.23 score. Kerala is the lowest with 70.59, and below that is your Tamil Nadu with 68.38. Highest devolution, that is division of powers, responsibilities, resources, etc. States which are performing fairly better is Chhattisgarh, Gujarat, Maharashtra, Rajasthan, Telangana, Tripura, Uttar Pradesh, West Bengal. Low performing states are your Jharkhand, Punjab, Goa, and Arunachal Pradesh. Okay, this might be useful for you in solving the statement kind of questions. Top performers in specific dimensions: finances and accountability, Karnataka; function wise, Tamil Nadu; framework and institutional setup, Kerala; role in governmental scheme, Uttar Pradesh. Okay, now let's learn more about the topic by looking into some of the questions. Consider the following statements regarding panchayat devolution in India. Panchayat devolution refers to the process by which powers and responsibilities are transferred from the state and central government to local governments. The 73rd Constitutional Amendment Act of 1992 explicitly mandates the devolution of powers to panchayats in areas of agriculture, education, and health. Panchayat devolution is aimed at ensuring greater participation of local communities in governance and promoting decentralized decision making. Now, the first one. Panchayat devolution refers to process by which powers, responsibilities are transferred from state and central government. Correct. 73rd Constitutional Amendment Act of 1992 explicitly mandates the devolution of powers to panchayat in areas of agriculture, education, and health. See, 73rd Constitutional Amendment Act mentions devolution of powers to panchayat, but it has not specifically mentioned agriculture, education, and health. Rather, it is about your social welfare, development. It is more broader aspects. The panchayat, the 73rd Constitutional Amendment Act, it has mentioned devolution, but it is very broad term topics. It is not your specific topics such as your education, agriculture, and health. And states will be the one who will be majorly taking the decision on this, and not your local bodies, that is, they are not given that much of devolution, is aimed at ensuring greater participation, governance, and promoting decentralization. Correct. So the correct answer is 1 and 3 only. Correct answer is C. Okay. Next question. Which of the following is part of the provisions related to Panchayat devolution under 73rd Constitutional Amendment Act? Creation of State Finance Commission to recommend devolution of funds to Panchayat, establishment of State Election Commission for conducting Panchayat elections, compulsory devolution of 50% of revenue collected by the state government to Panchayats. State Finance Commission, yes. State Election Commission, yes. Look at this compulsory devolution of 50%. No, there is no such provision. So, which makes only 1 and 2 correct, which is A only. Which of the following is a key feature of the Panchayat Devolution Index, which was introduced by Ministry of Panchayat Raj? The whole point I wanted to put this question was to make you aware of what is Panchayat Devolution Index. It measures the extent of devolution in areas such as agriculture, health, and education. It evaluates the decentralization of functions, finances, and functionaries to panchayat. It ranks states based on number of panchayat elections held in the previous year, monitors the expenditure of panchayat on national development projects. The correct answer is it evaluates the decentralization of functions, finances, and functionaries to panchayats. Under the 73rd Constitutional Amendment Act, which of the following powers is not explicitly mandated for panchayats? Planning for economic development and social justice, imposition of taxes on specific goods and services within their jurisdiction, implementation of schemes for poverty alleviation, preparation of plans for local economic development. See, again, in this question, everything seems like a possibility and not like a possibility because it is both a mix of generic and broad statements. Imposition of taxes on specific goods and services. Okay, yes, there is a provision where they can put certain they can collect few amount of money for a particular resource, but when we say goods and services, like if we consider it at the central level, state level, like a gst, the panchayats do not have that much of powers. Okay, now again, when we say with regard to implementation of schemes with poverty alleviation, they do not mean poverty alleviation from a bigger concept, that is to the level of your center and state, so that you have to keep in mind. The Panchayat Raj system in India is primarily based on which of the following principle? Decentralization of power, political centralization, economic equality, national unity. Correct answer is decentralization of power. Your concept of Panchayat Raj institution is from your you can associate terminology such as your grassroots level democracy, Gandhian principle, Gram Raj, Ram Raj, Swaraj, Suraj. Okay, these are all the associated terminologies. Decentralization, bottom up approach. The next topic that we will be talking about is your president's rule. Again, we are discussing president's rule now is because of the recent resignation of your chief minister N Beren Singh, and also imposition of president's rule. Okay, so with regard to president's rule, you will see what Sarkaria Commission mentioned, what Panchi Commission mentioned, what were their recommendations. When we come to Sarkaria Commission, look at just three keywords: last resort principle, prior warning, parliamentary approval. With regard to your president's rule, now when we say with respect to emergency, we have three sorts of emergency. The national emergency under Article 352, your state emergency or president's rule under Article 356, and your financial emergency under Article 360. Okay. Your national emergency has been invoked in India. Your presidential emergency or state emergency, president's rule or state emergency has been invoked in India. Your financial emergency has not been invoked in India, which means this has not been applied. Now, when we say Article 356 or President's Rule, this is one of the things that draws criticism because it is widely misused for a lot of reasons. Almost more than 125 times we have invoked. Almost every state has been once or twice under your president's rule for in almost this past 75 years. So, what Sarkaria Commission speaks about your president's rule is it has to be used as a last resort when there is no other option to use it. And before even applying president rule, let's say at that point of time, you can either suspend or you can even remove state legislature. Before applying or imposing president rule to a state, you have to make sure that the state is given adequate warning so that it can correct its course of action and this shall not be put on it. And the president rule should not be continued indefinitely, which means as soon as the situation is brought under control, it has to be revoked. And it should not be arbitrary. President's rule should not be arbitrary, but rather it should be strictly reviewed by your parliament and passed by both houses of the parliament. Let's see what Panchi Commission speaks on this. It is telling that three keywords. Look at this: localized emergency, stronger safeguard, time bound review. When we say local emergency, Panchi Commission recommends that instead of imposing precedence rule to the entire state, wherever the situation has got out of hand or where it has escalated, only apply it there. Okay, and then when we say stronger safeguards, first and foremost, they're telling your precedence rule should be used like same your Sarkaria Commission as the last resort, not as a solution for everything, and specifically should not be used only for political motives. In fact, it should not be used for political motives at all, but most times it is used for that only. That is the criticism surrounding this. Look at this: Meiti safety worry under president rule, Manipur peace efforts, president rule imposed in Manipur. This is the topic why we are discussing your president's rule concept. So, what is a president's rule? Simple: suspension of a state government, and also we will see which articles are giving effect to your president's rule. That is Article 356 and Article 365. Two different grounds on which a president rule can be invoked. Under Article 356 is when the president rule is imposed, where the state machinery has completely broken down and state cannot be run further. Whereas your Article 365 is imposed as a president rule is when the states fail to comply with the orders of the center. Understanding? States fail to comply with the orders given from the union or center. This is the two articles which will give effect to your president's rule. So, in simpler words, why will you impose governance? That is your president's rule. Breakdown of constitutional machinery, failure to comply with the central's directive based on governor's report, and other justifications such as your, let's say, in that particular state there is extreme violence to an extent that the state cannot be run. There is complete breakdown of machineries, constitutional machinery. So a governor's report is very much needed, where the governor tells that the position now is impossible for the state to run on its own. So a president's rule should be imposed. President's proclamation is initially for 2 months. Then it has to be approved by both Lok Sabha and Rajya Sabha if it has to continue with the proclamation. The duration initially it's imposed for 6 months and it can be extended like that up to 3 years max. Okay, wherein each 6 months it has to be approved by your parliament. Let's look some of the possible questions from this topic. Consider the following statements regarding president rule in India. President's rule can be imposed in a state if the president believes that the government of the state cannot be carried on in accordance with the provision of the constitution. Uh, The president can impose president rule without the recommendation of union cabinet. Under president's rule, the governor of the state assumes all executive functions of the state government. Look at this. Yes, the governor will assume all executive functions of the state. It can be imposed believe that the government cannot be carried on in accordance with the government. President can impose president rule without the recommendation of union cabinet. No, president will only act according to the aid and advice of the COM, which means second option is wrong. Only 1 and 3 are correct. Under which article of the Indian Constitution can president rule be imposed in a state? 352, 356, 360, 368. Correct answer is 356. Which of the following is a consequence of imposition of president's rule in a state? State will lose its representation in the Rajya Sabha. The president assumes all legislative, executive, and judicial powers in the state. The governor of the state assumes executive authority, and the state legislature is either suspended or dissolved. The parliament takes over all the powers of a state. This is a fairly direct question. I want you to comment down below what is the answer for this question. Okay? That's a fairly direct question. The next topic that we will be discussing is obscene laws in India. Again, this topic we're discussing because you would have heard of this recent news wherein your YouTuber Ranveer Alabadia of your beer biceps. So he alongside Usama Kraina, I guess, were put into or they were taken into charge under your obscenity over their show that triggered a major controversy. So, which makes us question how is obscenity dealt in India? First and foremost, what is this obscenity law there for? If you see, it is to make sure a balance between free speech with moral standards and prevent explicit content that corrupts public morality. Understanding? Now we'll see under what laws your obscenity is seen. Section 294 of Bharatiya Nyaya Sanhita, Section 67 of Information Technology Act of 2000, Indecent Representation of Women's Act in 1986. Okay. So you will see some of the key judgments in this I will be discussing with you. Ranjit Udeshi versus State of Maharashtra case wherein the Hicklin test was applied, ruling that your Lady Chatterley's lover is considered obscene. See, your Lady Chatterley's Lover is a novel which was in your European countries where, because of its explicit sexual content, many states, many countries had called it obscene. Wherein, again, when it came to India, there was a test, Hicklin test, meaning that if it corrupts innocent's mind, then if any content, any medium, any thought or any image which will provocate, which will disturb the innocent mind, then we can call it obscene. Based on that, they said that yes, Lady Charlie's Lover is obscene. The concept of thinking whether this obscene or not was done using this method, corrupts innocent minds or not. This was called as Hicklin's test. This was your European concept. Later, your United States of America and all at that point of time, with the changing community and that is changing period of times, they changed the manner to decide how obscenity should be decided. They thought that Hicklin's test is not probably the right way to decide, but rather this was the concept of USA, wherein they said that we will decide at that point of time, okay, at that particular period of time, if a normal person finds this, that is based on the society agreed upon rules, if that is okay, if it passes a particular set of community standards, then it is fine, otherwise it's obscene. This was a sharp contrast from your Hicklin test, which means they moved away in order to bring in a concept which will be more broader and accepted to the society's changing times, evolving period. In Avik Sarkar versus State of Bengal, your Supreme Court had shifted from the Hicklin test to community standards test. This is what I meant, community standards test. At that point of time, if the society is accommodating of that, then it is fine. Otherwise, it is obscene. So, on your Supreme Court in your college romance web series had quashed the obscenity charges against the YouTube creators, telling that vulgar language does not mean obscenity. Okay, let's look at some of the question. Which of the following can be associated with the interpretation of obscenity laws in India? Menka Gandhi versus Union of India case, K. Abbas versus Union of India case, Ranjit Udeshi versus State of Maharashtra, Shreya Singhal versus Union of India. It is Ranjit the Udeshi. Okay, next. In the context of Indian laws on obscenity, what does community standards test mean? Obscene content is determined solely by the majority opinion in the society. A universal definition of obscenity applicable in all cases irrespective of context. The determination of obscenity is based on the norms and values accepted by the community at a particular time. Obscenity laws apply only to public exhibitions and not to personal consumption. The correct answer is the determination of obscenity is based on the norms and values accepted by the community at that point of time. See, earlier, let's say in your 1900s, LGBTQIA representation might be considered wrong, even criminalized activity. But presently, that is not it, at least in countries, let's say India, USA. Yes. So, this is called accepted by the community at a particular time. So they brought out these laws to make sure it is broad and accommodative of time. Which of the following is true regarding Section 66A of the Information Technology Act 2000 relating to obscenity? It criminalizes the publication or transmission of obscene material online. It has been upheld by the Supreme Court of India in its entirety. It was struck down by the Supreme Court in 2015 as unconstitutional for being vague and overboard. It is still in force and applies to both print and online media. See, this section 66A, the Information Technology Act, a law student, 22-year-old, Shreya Singhal, had challenged the validity of the law, telling that it is violative of Article 14, 19, and 21, and it is excessively vague, intrusive, and can lead to, okay, your government taking arbitrary decisions. Based on that, Supreme Court held that yes, your section 66A is highly vague and overbroad, because when you are going to curb a person's fundamental rights, especially the rights such as your Article 19, Article 14, Article 21, this cannot be broad. This has to be specific. So, but this is violative of that, for which Supreme Court struck it down, telling it was unconstitutional for being vague and overboard. Okay, you have to know this about section 66A, which was your Shreya Singhal versus Union of India case. Which of the following describes the obscenity test laid down by Supreme Court in the case of K.A. Abbas versus Union of India? A test based on whether the material is likely to lead the criminal acts, a test based on whether the material can be understood by a reasonable person as offensive to public decency, a test based on whether the material is offensive to religious sentiments, a test based on whether the material depicts violence and crime. Correct answer is whether a material can be understood by a reasonable person as is it whether offensive to a public decency or not. So the correct answer is B. Next topic that we will be discussing is your Article 101 of 4. This we are discussing is because of your news circulating around your jailed MP Amritpal Singh, wherein it was worried that because he is jailed at this point of time and he has not been able to attend the parliament session for continuously these many sessions. So, will that mean he will lose his seat? Is there an alternative? According to Article 101 states that an MP seat may be declared vacant if he is absent for 60 consecutive sittings without permission. And just because he hasn't attended 60 sessions, that doesn't mean his seat will be automatically vacant. Only the House has to declare it. Is there a way around it, or is it just final? Because he is jailed, he is not able to attend it. So there are certain other cases. So the MPs must write to the committee on members' absence where it will be discussed and the House will vote on that. Okay. As of now, no one has lost a seat because of their attendance. Okay. The next topic that we will be discussing is your delimitation exercise. Previous topic, you just have to know the article. For that reason, I brought it out. Delimitation exercise, again, why we are bringing this, because this is surrounded around the news where your Union Home Minister had to make sure that your southern states, especially Tamil Nadu, telling that the delimitation commission, which will not mean that your seats will be reduced. Again, the delimitation commission is now a big headache, is because many states, in simpler terms, if you have to know what is delimitation commission, this will determine the constituencies, number of constituencies for your parliamentary and state legislative elections. This is done by your delimitation commission, which is assisted by your election commission. Your delimitation commission is one important body which will determine the number of seats. In 1970, specifically, I will tell you when the delimitation, the seats were frozen based on your 1971 census. Later, furthermore changes will take place, where they kept 2001 census will keep, but without changing the boundary. That is the seat sharing. So many of the southern states went ahead with rigorously following a family planning, brought the population under control, whereas some of the northern states, example like your UP and all, they have not been very successful. Now, if you see, according to the concept of delimitation commission, based on the population, the proportionality will be your seat share. So, which will mean the northern states will be getting higher seat share compared to the southern states. Why? It is like as if they are being punished for following the mandate or bringing the population under line or under control. So, this was one of the major troubles that was surrounding your delimitation commission. Now, how they're deciding to deal with this is what your topic is about. So, for your UPSC, you have to know about your delimitation commission. What is that? Fixing the number of seats and defining the boundaries of your parliamentary elections. That is your Lok Sabha, Rajya Sabha, state legislative assemblies. So, what is your delimitation commission doing? It is proportional representation based on the population. Okay, even for determining seats of your SCs and STs. Your delimitation commission is created by an act of parliament. Election commission will assist them in the process. The articles that are present is Article 82. After every consensus, Parliament enacts a delimitation act to redefine constituency boundaries. Article 170, states are divided into territorial constituency as per delimitation act after each census. 42nd Amendment Act of 1976 froze the number of Lok Sabha seats at each state for 1971 census level. So the last delimitation that we did was here 1976. 84th Amendment allowed territorial readjustment based on 1991 census without changing number of seats. 87th Amendment delimitation based on 2001 census, keeping the existing seats. Okay, so the seats were not changed. Up until now, delimitation has been conducted four times: 1952, 63, 73, and 2002. Let's look at few of them questions and learn more of this on delimitation commission. Which of the following statements are correct regarding delimitation commission in India? It is responsible for determining the boundaries of parliament and assembly constituency in India. It is a statutory body formed under Article 82 of Indian Constitution. A recommendation of delimitation commission are binding on the government, but they cannot be amended by the parliament. No, this is not correct. Correct answer is 1 and 2 only. The Delimitation Commission of India is constituted after which of the following events? Every 5 years after a general election, after every census of India, whenever the president deems it necessary, every 10 years, irrespective of the census. No, it is after every census of India. Which of the following statutory bodies are involved in the process of delimitation of constituencies in India? Election Commission, Finance Commission, Delimitation Commission, UPSC. See, Election Commission assess Delimitation Commission, but your Finance Commission and UPSC are not there. Correct answer is your Delimitation Commission. Which of the provisions the Delimitation Commission set up in India? Article 82 of Indian Constitution, 73, 80, 330. Correct answer is 82. We are bringing this topic again for you to know what is 82. Delimitation Commission works under the guidance of which of the following persons or bodies? Prime Minister of India, President of India, Chief Election Commissioner of India, Speaker of Lok Sabha. Correct answer is President of India. Next topic that we will be discussing is National Commission for Safai Karamcharis. Okay, Safai Karamcharis means basically someone who is involved with manual scavenging. What is the whole goal of this? And why is it in news? Mainly is because the cabinet has extended the duration of your National Commission for Safai Karamcharis for 3 more years, that is up until your March 31st, 2028. What is the whole point of your National Commission for Safai Karamcharis? To make sure your manual scavenging is completely removed, eliminated. National Commission for Safai Karamcharis was set up according to the Act of year 1993. It is under the Ministry of Social Justice and Empowerment. It is headed by a chairperson, vice chairperson, and 5 members. Usually, the chairperson will be of Minister of State level. They make sure they will see which any compliances are there or not with regarding to prohibition of employments as manual scavengers and their Rehabilitation Act of 2013. We'll see more about this topic in the form of questions. Consider the following statements regarding National Commission for Safai Karamcharis. The National Commission was set up under an Act of Parliament to address the issues faced by sanitation workers in India. Is primarily tasked with promoting welfare of Safai Karamcharis and working towards elimination of manual scavenging. Is a constitutional body that reports directly to the President of India. No. Correct answer is 1 and 2 only. It is a statutory body. Sir. National Commission for Safai Karamcharis was established to primarily address which of the following issues? Issue related to education and health of Safai Karamcharis, elimination of manual scavenging and improving socio-economic conditions, empowerment of backward classes and scheduled tribes, preservation of cultural heritage related to traditional occupation. Correct answer is elimination of manual scavenging and improving socio-economic condition of sanitation workers. National Commission of Safai Karamchari is primarily concerned with which group of workers in India? Teachers, farm workers, sanitation workers, factory workers. Correct answer is sanitation workers. The NCSK is empowered to perform which of the following functions? Investigate and monitor implementation of various schemes and programs related to Safai Karamcharis, make recommendations for the welfare and rehabilitation of Safai Karamcharis, provide financial assistance directly to individual Safai Karamcharis. First one is correct, second one is correct, third one is wrong. No, there is no provision to give financial assistance to individual Safai Karamcharis. So the correct answer is A1 and 2 only. The next topic that we are looking into is rarest of a rare doctrine. This has come into issue is because when we use the word rarest of rare, it means imposition of death penalty. In your RG car case and your other cases that we will be further discussing, you see that they are not using the death penalty according to some predetermined laws or any pre-met conditions, but rather they have held that in very extreme cases that you will use this. But again, this will be used according to your judicial discretion. We will discuss more on this. Look at this. In Jagmohan Singh versus State of Uttar Pradesh, Supreme Court upheld constitutionality of death penalty as it is not violative of 14, 19 and 21, which means they defended death penalty usage in India. In Bachan Singh versus State of Punjab, they established the rarest of rare doctrine, which means just uh, let's put it this way. A murder is committed Okay, doesn't mean that this will fall under rarest of rare and this has to be awarded with death penalty. They will see how and on what events this has led to the murder. For example, was it a hate crime, was it a serial killer, was it a person who goes around doing this, and in what way were they murdered, or was it in a different fit of anger. So how the crime was committed, which means how severe was the crime committed, is also looked into the case. That is when they even tell that when the judiciary's hands are tied, when there are no other options left, then only your death penalty will be used. That is in the rarest of rare occurrences only. So in your Machi Singh versus State of Punjab, they held that your rarest of rare occurrences, we can see these kind of things. Manner of crime, what is the motive of crime, what is the impact on society? Is it implementing some sort, or is it stating for some sort of hate crime against a particular section of people? And what is the magnitude of the crime? What is the victim's vulnerability? Let's say the victim was a child, elderly women. So these kind of things will be seen. Now look at this. We'll look at some of the questions. The doctrine of rarest of rare cases was evolved by the Supreme Court of India in which of the following landmark cases? Keshwanand Bharti case, Menka Gandhi's case, Bachchan Singh versus State of Punjab, Nas Foundation. It is Bachchan Singh case. See, again, this topic has come into issue is because the sharp contradicting way in which your Supreme Court had dealt with. For one side, you all know about your RG car case that happened in Kolkata. Another thing is contrasting with your Sharon case with respect to your Kerala, where a woman who was 24 years old, she was the youngest woman to be getting a death penalty in Kerala. Whereas this person who committed the crime in your Ajikar case was not given a death penalty. The case that involved in that Kerala, the Sharon case, was that the girl, 24-year girl, had poisoned and killed her a long time boyfriend. Here in this Ajikar case, they said that this person raped and killed a woman. And you have given death penalty to one and not the other. Why? So this is what again has brought it under the discussion. According to the doctrine of rarest of rare cases, which of the following factors is most likely to influence court decision to impose death penalty? Economic status of accused, severity of crime, and whether it falls within the category of being brutal, heinous, and cold-blooded. Personal circumstances of victim, social background of the accused. Correct answer is severity of the crime and whether it falls in the category of brutal, heinous, and cold-blooded. Doctrine of rarest of rare cases requires the death penalty to be imposed only in cases where the crime is of exceptionally heinous in nature and leaves the court with no other alternative but to award the death penalty. Crime is of political nature or related to terrorism. Accused has prior criminal record. Accused has confessed to crime in front of the police. Correct answer is A. This is considered like the last resort. In many cases, your higher courts, initially in the 1970s and all, have held that the courts should not be bloodlust, which means they should not take away the lives. They should be very much in restrained while utilizing or while using this rarest of rare scenario or when applying your death penalty. Which of the following statements is correct regarding the doctrine of rarest of rare cases? The doctrine is based on principle of retributive justice. Doctrine has been criticized for being ambiguous and inconsistent in its application. Doctrine limits the death penalty to case of terrorism and political crimes only. Doctrine suggests that the death penalty should be imposed in majority of criminal cases. The correct answer is doctrine has been criticized for being ambiguous and inconsistent. Like I just mentioned, in RG case, it was not given, whereas in your Sharon case of Kerala, it was applied. So this is where people have questioned that it is too ambiguous, but again, they have held that no, it is entirely under the discretion of judiciary. But people are asking, do you see the severity of the cases that is seen? So that is the criticism. The last topic that we will be discussing is your remission. Remission means basically you do not change the nature of the crime, this remains the same, but you only change the duration of the crime. That is, you shorten the crime period. Let's say a person was imprisoned for 10 years, now he can be imprisoned for 2 years. So what and all speaks about your remission? Section 2 473 of your BNSS, and this empowers the state government to grant remission. Article 72 and 161 of the Constitution allow president and governor to remit sentences, which means reduce the sentence. In Sangeet and Anar versus State of Haryana, Supreme Court ruled that remission cannot be suo moto, required an application from the convict. In Mohinder Singh versus State of Punjab, it reaffirmed that remission must be initiated through an application, not by the courts or government automatically. Which means, in simple, this is the past judicial judgment stating that if a remission, that is reduction of sentence, has to be given to a person, then it has to be via an application process. Now why it has again come into news is because now Supreme Court has held that application is not necessary now for considering the remission of the cases. Understanding? This is why we are speaking about remission. In totality, you have to know what the concept of remission is and associated articles for your prelims. Okay, that's it. We've come to the end of the content. If you have liked our content, subscribe to our channel, hit the like button, and share it along with your friends. Thank you.